Ladies and gentlemen, gamers and non-gamers alike, welcome to the thrilling world of video game lawsuits. Picture this, a courtroom filled with characters straight out of your favorite game, from lawyers in Mario overalls to judges wielding gavels that look suspiciously like foam swords. It's a legal battle where press start takes on a whole new meaning, and level up could mean a promotion or a lawsuit upgrade. I'm Professor Retro, and these are 11 video game lawsuits. Coming in at number 11 is Pong Magnavox vs. Atari. So back in 1972, Atari put out one of the oldest retro games ever, Pong, and it became a massive hit, and has been named one of the first video games ever made. Well, the creator of Magnavox Odyssey, Ralph Baer, played it and filed a lawsuit against Atari, claiming the Atari had copied the electronic Pong game after the co-founder of Atari, Nolan Bushnell, played it at a Magnavox Odyssey dealership. Bushnell saw the lawsuit and naturally laughed at it, but soon settled in 1976. His lawyer asked why didn't Bushnell take his advice to let go to court. Bushnell stated that since at the time Atari was a fledgling company, letting the issue go to court would cost the company more than they actually had. As for the outcome of this, well, Atari still sold Pong cartridges and arcade games, but had to pay licensing and royalty fees to Magnavox. Coming in at number 10 is PacMan vs. KC Munchkin, otherwise known as Atari vs. Philips. Here's another company who wanted to sue Atari over a game. So back in the 80s, PacMan fever took the world by storm, and eager to cash in on it, Midway and Namco took on the challenge of putting PacMan in arcades, and then a home port for the Atari 2600. However, a year before Atari debuted the game, Philips and Magnavox, oh good, they're at it again, debuted their game KC Munchkin, which looked similar to Pac-Man. So in 1982, Atari sued Philip Magnavox, claiming that KC Munchkin was an exact copy of Pac-Man right down to the T. The court did agree with Atari, and this case changed the way courts handle copyright when it came to look and feel of computer software. Coming in at number 9 is Nintendo vs. Tenjin. Now if you've been a retro gamer for as long as I have, you remember the strange religious games that came up for the NES. Well, these were the start of a licensed game made for Nintendo. Nintendo had very strict rules when it came to licensing games and getting the official seal of approval, and one of the rules was for third-party developers, and that was they could only make 5 games per year. Well, at the time, Atari had split into 2 divisions, Atari Games and Tenjin, and these 2 divisions wanted to renegotiate a less restrictive contract with Nintendo, and well, Nintendo wasn't having it. So Tenjin went over Nintendo's head to the U.S. Copyright Office to try to acquire the design for Nintendo's lockout chip. In short, it made sure unlicensed games would never play on the NES. Nintendo came up with a lockout chip so once you put in an unlicensed game, it would never play. However, Tenjin wanted the design to reverse engineer it so they could sell as many unlicensed games as possible. This angered Nintendo so much that they sued Tenjin for copyright and patent infringement. This case dragged out for years until the court sided with Nintendo, and in 1996, Nintendo and Tenjin settled the whole thing out of court. Coming in at number 8 is New Super Mario Bros., otherwise Nintendo vs. James Burt. Now this is a bit more recent one. James Burton from Australia got a hold of an early version of New Super Mario Bros. For the Wii. He then decided to upload the game to the internet, which ended up getting downloaded over 50,000 times in a matter of a week, before Nintendo had actually planned to release it on November of 2009. This, however, in and of itself is a clear no-no, since copying and distributing video games is a clear violation of Australian copyright law. Nintendo and James settled this matter out of court, and James had to pay Nintendo for the week of lost sales, plus an extra $100,000 for Nintendo's court filings and fees. However, never say Nintendo is ruthless. Since the matter was settled to their satisfaction, Nintendo sent James Burt a limited edition Legend of Zelda The Wind Waker statue. Coming in at number 7 is Smallwood vs. NCSoft. This one comes straight from the You Chose Do file. So a Hawaiian man by the name of Craig Smallwood sued South Korean developer NCSoft, who was the creator of the massively hit online role-playing game Lineage 2, claiming the game was, get this, too addictive. He claimed that he spent 20,000 hours playing the game between 2003 and 2009, and had averaged about 11 hours each time he played, thus making him so dependent on playing it to the point of addiction. And it took over every aspect of his life. He likened it to being addicted to hardcore drugs, and held NCSoft liable since they never put a warning on the game saying that massive multiplayer online role-playing games are addictive. The outcome of this was just as you would expect. The court just threw this out of court in 2011 and then referred good old Craig Smallwood to psychological counseling. Coming in at number 6, King Kong vs. Donkey Kong. This one is interesting. So in 1983, Universal Studios sued Nintendo and the creator of the massively popular game Donkey Kong, Miyamoto, claiming that he had based Donkey Kong and the story in the game after their movie King Kong, which was Universal's intellectual property. However, Nintendo countersued, saying that due to the case of Universal Studios versus RKO Studios, the maker of the original 1933 King Kong movie, for the movie's rights. In this one, Universal claimed that King Kong was in public domain since their 1976 remake with Jeff Bridges was so bad. So by now you're wondering, what does this case have to do with the case with Nintendo? Well, the court sided with Nintendo, saying that King Kong was indeed public domain property and was awarded $1.8 million from Universal Studios. Coming in at number 5, the O'Bannon and Keller vs. EA. So here's another strange one in my mind. Back in 2009, former college athletes Ed O'Bannon and Sam Keller sued massive developer Electronic Arts and the collegiate licensing company over unpaid royalties of their likeness in both NCAA basketball and NCAA football. NCAA and EA feared that this might cause other college athletes to sue over royalties in other sports games. This whole thing was sold out of court for an undisclosed amount, and EA had to stop selling NCAA football 2014, thus putting the whole franchise on ice. And coming in at number 4 is the Romantics vs. Activision. So if you were a gamer around the 2000s, you would have known of the game Guitar Hero. You know, the game where you play a peripheral that's shaped like a guitar with colored buttons to big hit songs? Well, for this, Activision had to get bands permission to play the games in their songs. Well, Activision got permission to use the Romantics' big 80s hit song, That Is What I Like About You, in the game, or rather a version of it. So even though Activision had permission to use a cover of it, the Romantics claimed the cover used in the game sounded too much like the original, and Activision fired back, saying that any cover of a song shouldn't sound like the original. So after a ton of back and forth between each side's lawyer, the court sided with Activision, saying that the Romantics had indeed given permission to Activision to use their song in the game, and the Romantics lost the case. But it's not over yet. The Romantics then tried to sue Activision for a bigger share of the royalties from the sales of Guitar Hero, Rock of the 80s, to which they also lost this time. At number 3, we have Olsen vs. Midway. This one came with a pretty gruesome crime that happened in the 90s. So a bit of background first. In 1997, a 13-year-old named Noah Wilson died after his friend stabbed him in the chest with a knife. So after his death, his mother tried to sue Midway, the maker of Mortal Kombat, saying that Noah's friend was so obsessed with the game to the point he thought he was Cyrax. Well, after a very long court case, the judge found that Midway was not liable for the death of Noah, and that if they were to try to stop Midway from making games, it would be a clear violation of freedom of speech. However, this case was one of the cases that started the ongoing battle over violent video games. Coming in at number 2 was the Olsen twins vs. Acclaim. So if you grew up watching the show Full House, then you remember the youngest character, Michelle, was played by a pair of twins, yes, Mary-Kate and Ashley Olsen. Well, during the 90s, their likeness was used to sell everything from lunchboxes to video games to kids. Well, Mary-Kate and Ashley sued Acclaim for back royalties to the oddly specific tune of $177,696.32. After the company Dual Star Entertainment split from Acclaim a year earlier. So what really caused this all to happen? Well, after Acclaim canceled Mary-Kate and Ashley in Action on all platforms, the lawyers sent in nice letters saying that Acclaim just blatantly abandoned their brand and the game, which flourished, and ran it into the ground. Well, Acclaim settled with them out of court and learned to never piss them off again. So before we get to the number 1 spot, here's some quick honorable mentions. Manuel Noriega vs. Activision. Now, when the game Call of Duty Black Ops 2 was being developed by Treyarch, the game caught the eye of the incarcerated Panama dictator Manuel Noriega. Well, Noriega wanted to sue Activision Blizzard for the use of his likeness. The case was thrown into court in 2014 to avoid the whole freedom of speech over historical figures nonsense. Bethesda vs. Warner Brothers Interactive. This one might still be going on due to how recent it is. When Bethesda struck gold with their hit franchise Fallout, they decided to try to make a mobile game based on it, and they created Fallout Shelter. Bethesda then saw that WB had created a game similar to it called Westworld. So Bethesda decided to sue Warner Bros. Interactive. This one went further than just similarities between the two. Bethesda said that WB was reusing the code from Fallout Shelter, thus making it a blatant ripoff. Well, WB fired back, and we still have no idea when this one will end. Bethesda versus Mojang. Yes, Bethesda is at it again. So back in 2011, after Minecraft was done, Mojang announced a second game called Scrolls. However, this pissed off Bethesda, and they sued Mojang, claiming that Scrolls was too close to the game series The Elder Scrolls. Now, in the eyes of the gaming community, this was just a necessary flexing of Bethesda trying to stop an issue that was never really there in the first place. This ended with Mojang not trademarking Scrolls and still holding the name as long as the game was not a competitor to The Elder Scrolls. And the number one spot is Jack Thompson versus every video game developer. Now, some of the games on this list were sued for having violent content. And well, the number one spot is no stranger to that. I give you Jack Thompson, the intrepid lawyer from Florida who tried to go after anything he deemed obscene. He claimed that a child who played violent video games developed brain development issues. He labeled GTA and Mortal Kombat as murder simulators, and any FPS games he thought were giving kids efficient killing skills. He made several of these lawsuits all over the states, and even took on a case that involved a death and a defendant that played violent video games. However, doing this cost him his legal license, and he was then disbarred by the Florida Supreme Court. Well, folks, that's a wrap on our whirlwind through the wacky world of video game lawsuits. From pixelated poultry to suspicious similar superheroes, it's clear that the legal battlefield of gaming is just as wild as any virtual realm. Remember, if you find yourself in a video game lawsuit, don't worry, just grab your trusted controller, channel your inner Phoenix Wright, and remember that the only thing more powerful than a lawyer is a well-timed power-up. Until next time, keep gaming responsibly, and if you must steal someone else's game idea, at least have the decency to put a mustache on it, and call it Totally Not Mario Adventures in Plumberland. And with that, I am Professor Rich reminding you to mash the like button, ring that bell, or smash the subscribe button so you get the heads up on my next video. Until then, peace out and see you in court.